extensively, Miller, as against an associate professor in the Institute of Miller Psychiatry, Miller. Only on the basis of the Human Rights Commission, Miller, it attracts doctrine of dictation, Miller, services were terminated. A pseudo inquiry, Miller, that was complied with, Miller, and we questioned the propriety of the order before the Honorable Tribunal. Ultimately, the Honorable Tribunal did not interfere, and the division bench, presided over by Justice Standi, Miller, the division bench heard the matter. Hearing concluded. Unfortunately, judgment could not be, Miller, telephoned. I mentioned this matter. Your lordships were of the opinion, observed, Miller, that will not kindly remind us, Miller, very, Miller, beer.
Let it come on 14th.
14th. Yes. Hearing concluded, judgment could not be delivered.
Both sides are there.
Now we are the same side.
But there have been two matters. One, Miller, I am.
Without informing the other side, I have mentioned.
He is informed. Informed and mentioned so that we can. Yes. We know that on that day it is not adjourned unnecessarily.
Yes. And Miller, another indulgence I am seeking, Miller. One transfer application was, Miller, hard and rejected. Miller, a lady, Miller, had exercised her.
I was transferred. I challenged.
I was transferred, Miller, and the transfer order is under court. Now, Miller, the authority had issued a letter asking me to join, Miller, to the Shillong, 1st of July. I did not join. My husband is a government employee, Miller, a school teacher. Father is sick, Miller.
What ground have you challenged the transfer?
It's against, Miller, policy, Miller. The policy, but I must tell your lordship, otherwise, Miller, I'll be failing in my duty. In the key form, Miller? In the form,
option form.
No, in the form, Miller, in the petition, I have said the matter may be listed on 10th.
Oh, 9.
But I am mentioning it before that. I must tell you, Lord.
Why don't you join before challenging the orders?
I know, Miller. Let me test. We
have not been allowing any such mentioning where the joining has not. The law is very clear.
Law is also very clear, subject to correction, Miller, if it is against policy.
No,
50, Miller. 50,
policy means in a transfer gives you a right only to consideration.
Miller, there is no consideration at all. Number one. Number two, 50 employees, Miller, who are there. Miller, let me have the pleasure.
Then let it come on 9th if it is already.
Miller, let me have the pleasure to embrace death at the hands of your lordship.
You should ask the petitioner to join. We are only indicating because we are maintaining consistency in this regard.
No, Miller, I tell you, lordship, Miller, since the consistency is a reflection of mediocrity, I know this bench is not.
We would rather be.
Miller, let me. Miller,
consistency is a strength for the judiciary.
Miller, may I have an opportunity to address your lordship? Only a privilege.
Go and join, then you come.
I will ask, Miller. In the event, Miller, Tuesday, Miller, if I fail, if I can pursue, Miller, I know it's a judicial mind, Miller. At the last moment, Miller, I can make a.
No, we will not, because the law is very settled. We have not been allowing anyone, so we will not allow this petitioner also, unless there is a case of malafide where the apex court says that in that case.
Let me place the fact, Miller. Then, Miller, only a matter of 1 hour, half an hour.
Half an hour in a transfer matter.
10 minutes. 10 minutes.
10 minutes you will
10
get.
Minutes. 10 minutes. Only 2 pages I will show. And Tuesday.
So it will come on the date that you have given in the mentioning slip. In the form, not before that.
9th. Oh, 9th. 9th.
Anyway, it will come as a motion matter on that day. It should come.
Which has been given in the presentation form. Presentation form 9th, I have said.
So it will come.
But, yesterday I have handed up the orders to your lordship. My lord got it.
Yes, we got it. There's something about some question of law. What is the issue?
It was regarding.
No, the apex court has said the question of.
Yes.
What question of law?
Question of. No. My lord has decided everything, and the judgment has been reported.
We have got it.
I'm great.
Item number 1.
This matter, my lord, the petitioner and the state has already a submission and that was submitting, my lord, your lordship raise certain pertinent question, not to answer me. Before coming to that question, will not may I calculate not the that the petitioner was interviewed by two examiners, instead of four examiners, not and the marks of two examiners, and thereby it was out of the candidates who were analogous for the appointment of Group A and B. Lord, if your Lordship kindly come to page 49 of the Lord. Kind of the paper. Where but paragraph 3. Mentioned.
Why three? No, why there is two? Yes, 49. We are at 49.
And it is mentioned that in pursuance of such instruction of the C, the applicant appeared in the same personality case and also personality case of PPA and could secure 158 out of stipulated 200 marks in the A interview and secured 80 marks out of 200 interview B, wherein from among the necessary 4 members, only 2 members being Sri Nurul Haq, chairman of the WBPSC, and Sri Kapil Chattopadhyay were present for the passport of the personality test of Group B, depriving the applicant of the allotment of marks by 2 expert members of the committee, including a sitting LGP. Page number, my lord. That 52H, 52H after 4 lines, after 3-4 lines. Selection procedure of WBCS executive examination 2011 are much erroneous and illegitimate made apparently with vested interest as the interview of the applicant for recruitment in service have been conducted by 2 members in the state and place of stipulated norm of 4 members who constituted the full quota, while in the case of the other participants of the same personal test, it had been conducted by 4 of the said section selection committee members. My lord, this was your lordship's second query, my lord, to me, that where is the pleading in your way where you have stated that the other members were interviewed by 4 members. Your lordship, kindly come to again, my lord. My lord, paragraph F, page 50. Paragraph F, page 50. Thereafter, the instant applicant has made a RTA application dated so and had sought for information with reference to the final score sheet of the selected participants of the state of the 2011 and copies of reference list as submitted by each of the participants in Group B as said for the WBCS executive examination 2011 and the comparison of the portion interview personality test of the successful candidates in Group B police service with the score sheet of the applicant would make it apparent that while the other participants in the selection procedure were interviewed and allotted marks thereof, by the stipulated 4 members of the selection committee. The instant applicant has been interviewed by the only 2 members present, therefore, and was thus deprived of being awarded the marks of interview personal details by the other 2 members of the selection committee, and neither the applicant has been awarded the average mean marks even. Lord, repeatedly, my Lord, it has been, my Lord, pleaded in the original application, my Lord, that, my Lord, then, my Lord, if my Lord, if I draw your Lord's attention to, my Lord, page 52, paragraph 8. Lord, after 3-4 line, etc. examination 2011 are much erroneous and illegitimate and made apparently vested interest, and the interview of the applicant for the recruitment of group B police service have been conducted by 2 members in the stage and place of stipulated norm of 4 members who constituted the full quorum, while in the case of other participants of the said interview, personally test, it had been conducted by 4 of the said selection committee members. So, my Lord, repeatedly, my Lord, consistently, my Lord, because, my Lord, pleaded, and it was a reality, it was a fact that, my Lord, I was interviewed by only 2 members, I was given the score of 2 members, whereas, my Lord, other interviewers, other candidates, my Lord, were awarded by the full board, and, my Lord, that's why, my Lord, the next paragraph, the instant application after 4 lines, my Lord, the instant applicant mentions also the presence of an expert member in the interview for recruitment in the specialized services is invariable, and in the matter of interview of the applicant, the expert member seeking ADGP was not available along with advisory member, but subsequently, in spite of their availability, no marks have been allotted in favor of the applicant on account of those members along with the seeking members, including the chairman. That is, my Lord, here also the same thing, my Lord. Thereafter, my Lord, my Lord, I have to satisfy your Lordship about the composition of the board. About the composition of the board, that how many members, my Lord, were there. Lord, according to the petition of your applicant, I refer your Lordship, page 49, paragraph 1, that, my Lord, it was categorically stated that there were only 2 members, and you know the name, you mentioned the name. And what was the, my Lord, statement of the, my Lord, PSC in their reply to the will? I am taking your Lordship to page number 106. Your Lordship, paragraph 6. Statements made in paragraph 6B and 6D of the said applications are matters of record. So, my Lord, they have admitted what I have pleaded in my paragraph in 6C and 6B, in 6C and D. Then, my Lord, I have shown your Lordship other paragraphs, that is paragraph E and H. If your Lordship kindly come to their reply, page 106, paragraph 7, my Lord. Statements made in paragraph 6E and 6A of the said applications are matters of record. So, my Lord, from their reply, it will be, my Lord, proved that they have admitted my contention that others interviewers were, my Lord, interviewed by a full interview board, that is composition is 4 members, that they have admitted in their reply. My Lord, again in paragraph page 107, my Lord, paragraph 9, my Lord, they have asserted that I state, my lord, in third line, my lord, of para 9, I state that the applicant points out the fact that there were two members present in the board while his interview was conducted. This is one of the further admission, my lord. Then, my lord, your lordship kindly turn to page 108, my lord. Lordship, the interview board of WBCS executive, etc. 2011 for Group B service were conducted by 3 members, including the presiding member, that is the chairman of the commission. The members who interviewed the petitioner allotted their individual marks. So, my lord, out of 4 members, 2 members have given their individual marks, that is 40 and 40. 80. Your lordship may remember that in Group A interview board,
Please read G also.
my lord,
It's my choice, my lord. Since you're reading it, I just
my lord, in paragraph B, column E, my lord,
So according to them, how many were absent?
2 members were absent.
According to them.
No, my lord. Yes, according to them also, because they have given inconsistent statement, misleading statement in the writ petition itself. And
And
they have pointed out, my lord, one thing, my lord,
and this C is means nothing. C at page 108 means nothing.
nothing. Because 3 members, your lordship kindly consider, there were 200 marks in the hands of the interview board. Then, my lord, if 3 are the members who hold the interview board, how could the marks should be divided? And, my lord, I will show you,
We
lordship.
are not asking by inference. We are saying what is their case as per C.
Their case, my lord,
As per their case stated in C
in C,
is that there were 3 members.
C, there was, my
So
lord,
there is no admission of 2. They say 3.
my lord, they have stated,
There is specific government that there were 3.
they have specific government 3, they have specific government 4. I will show you, lordship. Kindly come to the writ petition paragraph, my lord.
No, writ petition means nothing.
My
It is whatever case they brought before the tribunal.
my lord,
That is the case which we are considering.
before the
We cannot allow them to improve or you to improve in the writ proceeding.
I don't want to improve.
Therefore,
There is a question of improving.
either cannot improve.
My lord, I cannot.
It has to be considered as per the records before the tribunal.
Hold on, your lord.
Yes.
Lord, the RTI information, my lord, which was provided to the petitioner, which was referred by my learned friend, but that was not read out as a whole. That is, my lord, page. My lord, page 63, my lord. My lord, regarding fourth query, the interview board of West Bengal Civil Service Examination 2011 for Group A and Group B service were composed of 4 and 3 members respectively, including the presiding member, that is, the member of the commission in each case. The lordship, that time, my lord, my learned friend has not read out the whole thing, my lord. It is to be mentioned that
You were interviewed for B.
And my first option was B. I was interviewed for Group A. They are out of 200, I got 158. Why 4 members?
No, your option was B.
My option was B.
So the
Lord, had they, Lord,
The
given me the
all right, you continue.
Sorry. Very sorry.
We are trying to understand something. Everything we say is not against a council or against the party. Yes, we are saying you participate. This deficiency in quorum is alleged with regard to the B. Yes. Now you proceed, please.
Now, my Lord, page 63, what I am, Lord, showing you, Lordship, which, if it is read, my Lord, as a whole, here you will Lordship found that there are another member. It is to be mentioned that apart from the 3 members, that is advisors, and 1 presiding member of Group Service, the Honorable Chairman also selected a member of this commission for the same board to act as a member of this commission. So, my Lord, what is my submission, my Lord, respectful submission, and what is the what happened, my Lord, in the case of interview, my Lord, that there were 4 members, not 3 members, my Lord. And, my Lord, in the last line, if your Lordship kindly come to regarding query number 8, of that page 63, the members who interviewed you were allotted individual marks. So, my Lord, that is why I pointed out that they have mentioned, my Lord, in the writ petition that, my Lord, in Group B also there are 200 marks. So, my Lord, that is why, that is in
Yes. Which part you are reading?
that part, page 63, last line of below. The members who have interviewed you were allotted individual marks.
Yes.
So, my Lord,
Yes. So what is the relevance of 8th query according to you? Relevance of the 8th answer to the 8th query according to you?
relevance is, my Lord, what I am to point out before your Lordship and to satisfy your Lordship, that the proportionate potent method is, my Lord, inbuilt in the rules of procedure. And that is why, my Lord, every interviewer has got the equal marks. So, my Lord, they have admitted that Group A and Group B, there are 200 marks for the interviewers. So, my Lord, if there is 4 interviewers, every interviewer has got 50 marks each. And they are to award on the basis of assessment, my Lord, out of 50. But in this case, my Lord, they are taking an inconsistent stand that it is 3 members. My Lord, that cannot be, because I know personally, I have made evaluate everything, my Lord, and they have admitted, my Lord, in their original application, in the reply to the original application, that, my Lord, the matters are, my Lord, fact. These are the matters of fact, these are the matters of record. These were the admissions of the, my Lord, PSC. And moreover, if your Lordship kindly turn to page 22, page 23 and page 23. Kindly come to page, Lord. 34. Page 34.
Round.
My lord, the petitioner, paragraph 22, the petitioner submit that as per the West Bengal Public Service Commission rules procedure, normally for the personality test, the interview board constitutes of 5 members, including one government representative, who is not supposed to award any marks but supervise the entire proceedings in the personality.
You asked us to turn to page 34.
My lord, the 24. Paragraph 22. my lord. The petitioner submit as per the West Bengal Public Service Commission rules and procedure, normally for the personality test. The interview board constitute of 5 members, including one government representative who is not supposed to award any marks that but supervise the entire proceeding in the personality test. Here they have not stated A and B, any difference is there. Then paragraph 23. The petitioner submit that as per the contention of the respondent number 1, in the interview board of Group A service, all the members were present, but in the interview board of Group B service, there were only 3 members present. Hello,
We have already told you that we'll go by the pleadings in the OA, and you are reading averments from the writ petition. Show us the averments in the reply filed in the OA. Why should we go by this?
Then Lord,
Once we have already told you, why are you undertaking an unnecessary exercise? We are not going to look at it. We are making it very clear to you. Yes.
Paragraph 6. Paragraph 6, that the instant said applicant states that in appreciation of the 2 said documents from the said compliance report of the PSC itself establishes it hearing that the said applicant's claim of Group B service within WPSC is justified, which is having no kind of encumbrance of doubt about its sanctity, bona fide character. It's pertinent in mentioning with reference that such kind of position hearing is to prove that number 1, strength of the said interview board Group A was 5, in actuality comprising of the Honorable Chairman PSC as the presiding member, along with the other 4 members of the PSC, thereby forming the 5-member board for the interview purpose, being part of the selection process of WBCS executive adjournment.
Yes.
Similar page 90. Date of interview board PSC for the group B.
That is your case. We know. Why are you reading your application? We know that is your case. You assert that there should have been 4 here also. Why are you reading yourself?
That has been, my lord, that has been, my lord,
Why are you reading your own pleadings? You have already said that according to you, there should have been consistency. Both the boards were required to be of 4 numbers. You have said if it is 3, then there is no way it can be apportioned amongst 3. All these things you have submitted. Now you say it is admitted that there were 2 members, and only for you. This we have yet to find. That admission we have yet to find. There we are making it clear. If you want to show it. Don't repeat the same thing again and again.
I'm not repeating, I'm only referring those portions where, my lord, it has
Not required. You have already said that. Obviously, you will assert that in the OA.
my lord, in paragraph, my lord, in page 101.
No, please don't take us through your plane.
My lord, there is not my plain, my lord. This is the reply of the.
Yes,
Yes.
we have seen the reply. Which part you are relying upon to show that there is an admission?
My lord,
Tell us.
6.1 and 2 of my lord. 6.1 and 2, which I have deferred just now, my lord.
That you have already placed.
My lord, this is statement made in paragraph 6.1 and 6.2 of the state affidavit on matters of fact.
Yes.
This is the, my lord, this is the reply to the supplementary
All right,
affidavit.
all right, all right.
Supplementary affidavit, not
Yes.
the original reply.
Yes.
Then, my lord, thereafter, my lord, I show your lordship page 102. They are taking the plea of delay, my lord. Then what they state? 102. I state, my lord, 3 lines. After 2 lines, my lord, I state that the Honorable High Court disposed of the petition application of the petitioner while providing him an opportunity for a fresh cause of action over the very case. Similarly, it is their admission, my lord, that I have filed only when the, my lord, the court has given the liberty, my lord, to raise the, my lord, the
Very well.
for the fresh cause of action, my lord, I have stated. And my lord, if your lordship can see from the date of order and from the date of filing the original application, there was no delay as required, my lord, under the, my lord, Administrative Tribunals Act. My lord, 1 year is there of filing the application. My lord, the date when, my lord, the Honorable Court passed the order, within 1 year, after 6 months, my lord, we have filed this original application, my lord. There is no delay.
Within the 6 months of which order? Show us that order.
My lord, that order, my lord, Lord,
Yeah, but
the lordship guide us page 79.
specifically asserted.
But I find this application,
Yes. Take this thing.
Can I have my lord's kind leave?
Yes. Just show us where is that the order of the High Court.
the order of the page 79. And before that, my lord, what I want to, my lord, place before your lordship, what my lawyer has stated is the on the date of supplement, without showing you your copy of the written application, that I have not pleaded, my lord, that I was interviewed by 2 members and my lord, others were interviewed by 4 members. Kindly see the, my lord, I brought the, my lord, petition also.
We don't want to see that. We'll go by the OA. We will not travel beyond the OA at all. We are saying we will not travel beyond the OA. Yes, we have seen that already. Yes.
In the 3rd paragraph, the petitioner is aggrieved by communication so and so of the Public Service Commission,
Yes.
by which the petitioner's prayer for disclosure of the preference list was rejected on untenable grounds, while the final mark sheet was furnished to the petitioner. It would appear from the decision of the Information Commission that the State Public Information Officer was directed to provide the record. Since the respondents are not represented, then my lord, the last paragraph, respondents are directed to file a report bringing on record the reasons for the non-disclosure of the preferences of the petitioner as well as the final score sheet. My lord, score sheet is the, my lord, there are difference of mark sheet and score sheet. Mark sheet, my lord, is the tabulation of marks, and the score sheet, my lord, it is, my lord, held by the members of the board, authenticated by them, and the marks they have awarded against that they have, my lord, the score which was allotted to them. And that is the document which I was, my lord, consistently playing before them, and the Information Commission directed, and they have not provided, and thereafter, my lord, this was the thing, my lord. If your lordship kindly see the next page, my lord, next order, my lord. Next order, my lord, the same thing has been, my lord, mentioned that the relates to the final score sheet after 7-8 line, my lord. Relates to final score sheet for mains and interview. Had they produced, my lord, the score sheet, either of me or of any candidate, my lord, everything would have been clear.
Yes.
My lord, that they have suppressed and withheld. And my lord, because of the reason, my lord, they have some malafide intention. They have acted arbitrarily in denying the, my lord, rightful claim of the petitioner to, my lord, recommend his name in the Group B post. And my lord, lastly, my lord, it is my learned lawyer that who, my lord, has gone out of the track, my lord, and couldn't point out the two orders before the Honorable Court. Page 83, my lord, kindly see. Upon perusal of the report, it appears that the PSC has enclosed a merit list of Group B Service West Bengal, Police Service West Bengal, which contains at least two names having better margin compared to the petitioner. Then the last line, my lord, 84. The merit list gives a fresh cause of action to the petitioner. That is the, my lord, thing which I have, my lord, intended to point out before your lordship.
So no delay. All right.
So there is no delay.
Yes. Now,
Moreover, my lord, moreover, they have admitted that since 2015, consistently, my lord, I was asking them to provide documents. And
whether earlier whatever you were doing, 84 is now what else? Tell us.
actually, they have suppressed the material thing in their pleadings because the matter goes to the first appellate authority, they have not pleaded. The matter goes to the second appellate authority, they have not pleaded.
Yes, yes.
Then, my lord, they have not pleaded, my lord, the material, my lord, the statements which amount to fraud with the court, because they have to state all the facts. When they are challenging the order and they have come before the court, they should approach the court with clean hands, but they have not done so. And, my lord, because of non-production of the, my lord, the score sheet, which is a vital one, my lord, the petitioner is entitled to, my lord, have the benefit of, my lord, 114G of the, my lord, Evidence Act, because in the light of destruction of score sheet, the principle of adverse presumption under 114G of the Indian Evidence Act becomes present. My lord, I am referring to the judgment of Union of India versus Hina Devi, which is relied in para 72 and para 22 of the.
You have you challenged the order of the tribunal?
My lord,
You have challenged the order of the tribunal.
you have not-
Why are you arguing these things?
My lord, these things, my
You
lord,
have not argued these things before the tribunal. Where is the question of show us from the tribunal's order?
tribunal sort of, my lord, kindly see, tribunal considered that.
Yes.
Because that is why, my lord, my learned friend has
So
not
then,
said-
if the tribunal has considered you have not challenged, then why are you arguing again?
No, tribunal has accepted our proposal.
So therefore, you need not argue that. That's what we are saying. Unnecessarily, we
Take, my lord,
say something which is relevant. Don't just consume the time like this. Patience does not mean that you will start saying everything.
page 75, 76.
Why are you showing this? To show what? To establish what point?
That was the direction, but that was not given.
So how does it matter today unnecessarily? You think it is helping you in any way by showing these things? Then you please continue.
Lord, they have find so many documents here, but in their way application is their reply, they have not brought any document record to show their stand. What they have stated in the lead petition is different, that there were 5 members and 4 members. They have given 2 names, my lord, of the advisors who are retired, but they have not given the names of the expert in a specialized service like judiciary, Indian Forest Service, or West Bengal Forest Service. The expert member, presence of expert member is a must, and here they have not disclosed that fact. So, it has code was composed of 4 members. And now I am to show your lordships that the
Yes.
I am showing from their rules and procedures, your lordship.
Yes.
Page 189. But para in the said interview board, the commission may request an officer of appropriate rank ordinarily, not below the rank of joint secretary or head of additional head of the directorate, nominated by government to represent the department directorate for which recruitment is made. So these they have avoided.
All right.
So next E. Attempt should be made to come to a unanimous decision. That is the proportionate quoted is very much inbuilt in the rules and procedure. Here your lordship would found if the members of an
Yes.
interview
Yes.
of 2 or more members fail to arrive at a unanimous decision regarding the suitability or ranking of a candidate, the matter should be decided by taking the average of the marks given by the members. So the proportionate quotient method, page 189, my lord, paragraph E. Then, my lord, kindly come to page 205, my lord. The tribunal has taken consideration of this, my lord. My lord, paragraph C, my lord. In such situation, the method known as proportionate quotient (PQ method) would only be adopted, which seems to be more reasonable for redressing the grievance of the petitioner. The proportionate quotient is based upon the proportionate marks to be awarded to the petitioner on the basis of average marks obtained by him in other papers of BA degree which he has already been ordered accordingly. This was the reference of the case of Radha Devi versus Himachal Pradesh, decided over by the Chief Justice, was relied upon, and thereafter, my lord, the question has been raised, my lord, that whether PQE is applicable for all the candidates. That was also a question before by your lordship. That they stated,
We have not asked such question.
my lord, they stated that it is applicable to all. My lord,
We have not asked such question. This PQ has been devolved by the tribunal to grant relief. Whether they could have done it or not, the tribunal could have done it or not, that is what we have to see. Yes.
and my lord, the illustration they have given, my lord, that illustration is fallacious, wrong calculation, and everything. Your lordship, they have firstly, my lord, they have given the total marks. Then upon the total marks, they have made a my lord proportionate quotient, and they my lord showed a my lord, huge number, my lord, which is not correct, because they have given the illustration by 2 and 3. My lord, here their number kindly see, my lord. Their numbers are, my lord, 130, 1.
Where is the method according to you which the commission claims it has adopted for giving this proportionate quotient?
My lord, that is the average marks of the
Where is it? Where have they said how they have done it? You said they have given a wrong basis. Where have they given that wrong basis?
wrong basis, my lord, that is paragraph 24.
Of?
of the petition.
No. We are not looking at the writ.
Nowhere in the my lord, in the way applications, nowhere they have stated. Because the Honorable Tribunal, my lord, has only directed, my lord, since there is no claim before the my lord Tribunal that other candidates were, my lord, also interviewed by 2 members.
They have, how can they? They say 3 members. How can they claim
They
2?
say 3 members, but
Yes.
the amount, the marks which were shown, my lord, 130. So if there was 3 members,
That is your assumption. That is your assumption that it is impossible. We don't know. We will see whether it is impossible or not.
my lord, if your lordship kindly
So
see
three persons cannot be part of 130 marks. That is your assumption.
my
That
lord, my
that
assumption-
is a very unique assumption, but we'll see what it is worth.
I heard this cannot be a weak assumption because of the fact, my lord, they have stated.
No, according to you, it is a very strong assumption. All right. Now you proceed further.
Stated, my lord, that 200
And whether the tribunal and the high court should reappreciate the marks and grant of marks and evaluation done by the commission, that is another issue. So let's see now what other point? Yes. No, it is as per law, not as up to us.
My lord, they have denied, my lord, the notional seniority. My lord, in their reply, my lord, if your lordship kindly see. They have admitted the notional seniority in their way. If there is any illegality, then the candidate is entitled. My lord, if a candidate is, my lord, deprived of giving his, my lord, marks in the, my lord, interview.
Yes, there is a gross irregularity and illegality. According to you, we have understood that. So therefore, there was a basis for granting the notional seniority.
My lord,
What is this, sir? How do you do like this? I don't know. This is a conference chamber. What is it? Courtroom.
my lord, these, I'm referring some judgments of the Supreme Court.
Yes, give the judgments.
So, my lord, notes of the submissions which are made.
No, notes we are not. We have taken. We will not take into consideration. We will not take into consideration the notes. We are making it very clear. Yes. After so much of argument, we have taken notes, but yes.
judgment, my lord, I'm not, my lord, pressing before your lordship since, my lord, my lord, on the point of 140. Next judgment, page 20.
Page 20.
Page 20. Next judgment, my lord, that is the state of Bihar.
Yes.
Page 6 of 11. 6 of 11, my lord, from paragraph 11. From paragraph 10, what's my lord, I'm sorry, Lord. As earlier noted, the respondent entered service only on 10/2/1996, and yet under the impugned judgment, the High Court directed counting of his seniority from 2011/1985, when he was not born in service. The jurisprudence in the field of service law would advise us that retrospective seniority cannot be claimed from a date when an employee is not even post in service. It is also necessary to bear in mind that retrospective seniority, unless directed by court or expressly provided by the applicable rules, should not be allowed. As in doing so, others who had earlier entered service will be impacted. To challenge the conferment of retrospective seniority, the learned counsel of the appellant was cited Shitla Prasad Shukla versus State of UP and others, where this court speaking through Justice M.P. Thakkar rightly held the latecomers to the regular string cannot steal a march over the early arrivals in the regular queue. On principle, the appellant cannot interfere, therefore succeed. What is more, in matters of seniority, the court does not exercise jurisdiction akin to appellate jurisdiction against the determination by the competent authority. Well, so long as the competent authority has acted bona fide and acted on principles of fairness and fair play. Here, my lord, this portion of the judgment is, my lord, very much relevant in the context of the present petition, my lord, because the Public Service Commission has not acted bona fide and, my lord, following the principles of fairness and fair play. In a matter where there is no rule or regulation governing the situation, where there is no one but is not violated, the court will not overturn. Then, my lord,
Yes, you will rely on paragraph 14. With now the next judgment. Yes, now with next judgment on which point?
then, my lord, then, my lord, the judgment, my lord, of 2014 SCC online
On the same point, yes.
on the same point.
Yes. Now what other judgment? 2000 volume 8 SCC. This is on which
2000, my lord, paragraph, my lord, 16. Paragraph 16, last page, my lord.
so this is on the all these are on the same points.
They are taken, my lord, so, my lord,
Yes.
where there is the illegality or, my lord, the authority acted arbitrarily, my lord, the notional benefit and, my lord, the other benefits can be, my lord, awarded.
Yes.
Paragraph 36 and 37, my lord.
What is the point involved?
Here, my lord, the retrospective effect and, my lord,
How many judgments you will give on the same point? Why do you have to give 4 judgments on the same point?
Consistently, the Supreme Court.
So why do you have to give 4? If the Supreme Court says once, it will not be binding on us. What is this unnecessarily multiplying judgments?
Lord, sum up, Lord, my contention is, Lord, that the petitioner has, Lord, established a case before the Lordship that he was deprived from his legitimate claim of Lord funds, which are to be awarded to him against the interview. Which was
So
done
if
by-
we have understood correctly, your case is interviewed by 2 persons. The quotient could not be divided even if it was 3. The quotient has been divided erroneously on the total marks. And then under the circumstances, in view of the deprivation, you are entitled to the relief which was granted by the tribe. That is your case.
And the Honorable Tribunal, my Lord,
All right.
in the judgment, my Lord, passed each and every point has
Yes,
been
yes.
analyzed, and my Lord, analyzed the entire thing, my Lord.
Yes.
And came to a conclusion. And the last 2 orders, my Lord, which they have, my Lord, without challenging a single order in a writ petition, they have challenged 3 composite orders. No leave was sought from the court that, my Lord, leave may be granted to, my Lord, the challenge the 3 orders. There, my Lord, that is clarificated. And, my Lord, in all the orders your Lordship would found, they have not taken the plea of, my Lord, delay in before the, my Lord, tribunal. They have not.
Where is delay? You have already shown page 84. You have shown page 84 that after the High Court granted leave, and now again you are on the point of
We have not, my Lord, hesitated anything, my Lord, and the state also. Your Lordship will found from the last order also. State has nothing said, my Lord, save and except that, my Lord, the vacancies which cropped up in 2011 has been filled up. That is their submission. Nothing else. They have not, my Lord, filed any reply. They have not controverted any allegation whatsoever. So I fervently appeal before your Lordship that the petitioner, that the respondent, the appeal filed by the petitioner, being a misconceived and because of, my Lord, the statement they have made which are not tallied with the documents, my Lord, their applications may be dismissed.
Yes.
May I just give a very short reply, Lordship?
Yes.
Lordship, the point Lordship was pleased to ask them
Lord,
where we have
May I interpret one point which I have made? Lord, he got 80. 80 divided by 2. Then it comes to 40. That is the individual marks into 4.
Yes.
But the calculation is concerned, my Lord, they have given me 80. And my Lord, 80 divided by 2. Then comes, my Lord, individual marks 40. 40 into 4. Then, my Lord, with full boards, my Lord, marks, that would come to 160. So, my Lord, if so, my Lord, if
Yes.
so, my Lord, his total marks will be into 4, that is 160. My Lord, the other candidates got 130 out of 4 members, 110 out of 4 members, because it cannot be out of 2 members. Because individual marks are allotted and they have stated in their paragraph it is 200 and it is given by individual members. So, my Lord, if, my Lord, their contention is taken into, their illustration is taken into account, then my lord, they would have been given 4 interviewers mark, additionally 2 interviewers mark. So my lord, they will be jumped upon that. So that cannot be my lord the rationality, because they are entitled only my lord, and they have never complained. They have never complained to anybody, any authority, even PSC, and they have never approached any court of law that they were discriminated.
All right. Yes.
Much obliged to you.
Lordship, I'm not repeating what my learned senior has already submitted and not going beyond the reply given in the AO Lordship, OA Lordship. Lordship, the point I would like to place, Lordship, reply to the OA, page 108, Lordship.
Yes.
Lordship, here in point number C, we have specifically stated that the interview board of WBCS 2011 Group B services were conducted by 3 members, including the presiding member, that is the chairman of the commission.
Yes, in C.
Yes,
At
C.
C. Yes,
C.
we have seen that.
Yes, Lordship. Lordship, the other 2 points I would like to show, Lordship.
Yes.
The E. In case of absence of any member who is supposed to be present in any interview board, the usual practice of the commission is that the honorable chairman, in consultation with the members present in the interview, takes decision accordingly, and in support thereof, I have annexed the rules of procedure, which I am not going, Lordship. Lordship, the main point is G, Lordship. The same interviewing panel evaluated all the candidates on that very date. His contention is he was not evaluated. He was singled out. We have specifically stated in our OA Lordship, the same interviewing panel. Second, Lordship, in page number 100, that is reply to the supplementary affidavit. Here also we have stated category, Lordship, paragraph 5, second subparagraph, page 100.
Yes.
Paragraph 5, second paragraph. On the other hand, the interview board for Group B services was attended by 3 members, including the presiding member. In this respect, also, I have annexed the note sheet, Lordship, which we have placed while arguing. And the second paragraph, the allegation of awarding marks by interview board in personality test of Group B service because of absence of 1 member is mere self-assertion of the petitioner and not substantiated. We have dealt with that, Lordship. And Lordship, just to summarize, Lordship, our main case was constitutive res judicata, as High Court has not gone into these points. Judicial review, not permissible. Court cannot direct appointment. Retrospective seniority cannot be taken into consideration. And grant of proportionate quotient is not at all applicable here. Still, Lordship, we have tried to given the illustration following the orders passed by the tribunal, Lordship. Following the orders passed by the tribunal, we have given the illustration. And the next is participation in interview. Without any objection, he has participated. No contemporaneous objection raised, and which is estoppel from challenging.
So no
And
objection at the time of participation, but immediately after interview, did he object?
3 days, after 3-4 days, Lordship, not immediately. And the affecting seniority, affected parties have not been impleaded, Lordship. Tribunal has given the direction for the retrospective seniority by passing all the candidates who have already working for so many years. The affected parties have not been made part. This is my humble submission, Lordship. We have
Has said notional seniority, not actual seniority.
And our main case is there was 3 member interview board was consisting of 3 members, and all of them, all the interview board members have allotted marks, Lordship.
Yes.
So this is my humble submission.
For the parties.
And I'm not distinct.
Direct Recruit Engineers Association case of 70s, that is the leading case. Before a person is born in the cadre, it cannot be done. They are saying where a person has been wrongly denied, then the court can do it. So we'll consider. You may give it. Law is well settled on that point, but you may give. Must be referring to that direct.
The supplement one person will lift out. Now then you will not have any notice. Right?
This is for our reading, not for this case. Yes. Thank you.
My lord.
For any. Sorry for any.
Yes, next case.
Item number 2.
The matter was already disposed of. Milord is appearing at my instance. Milord, we Milord prayed for liberty, Milord, to withdraw and Milord file afresh, Milord, providing Milord some furnishing some more details. My lords were kind enough, Milord, to grant us that liberty, Milord, by passing an order on 20th of June.
Yes.
Now, Milord, the certified copy of the impugned order is, Milord, with my lord's file, Milord, that was, Milord, annexed.
Oh.
Milord, may I have my lord's kind liberty to
Yes. Matter has been
at a certificate?
Item number 3.
Your Lordship, item number 3. Your Lordship, item number 3, I am for the petitioner from Little Unwell down with fever. I was praying for if the matter could be taken up on Tuesday, Your Lordship. Tuesday or Wednesday, subject to Your Lordship.
as prayed. 1 week. Give 1.
Obliged, Your Lordship.
Oh,
Lordship, I beg to appear on behalf of the petitioner. Lordship, this is against a original application arising out of the Central Administrative Tribunal of 2018.
What has been done?
Uh, so the last date was, Lordship, on the May 16th. The only prayer in this is innocuous prayer for expeditious disposal of the original.
Sorry, we are not doing that. Yes, take down.
My lord, I'm praying for an extension of 1 week to file the reply, my lord.
Yes, time for filing.
Six. Item number 6.
Not today.
Seven.
Item number 7, I'm praying for a short pass. When Mr. Joyantran Chatterjee is appearing, he's coming, my lord. He's on his
Start,
decks,
he
my
will
lord.
come. Don't worry, we'll see the order by then.
My lord, the petitioner was discharging his duties as the assistant professor of forensic medicine and toxicology at the College of Medicine and Sagar Datta Hospital. Now, my lord, the transfer order was issued to him on 26th of July 2022. I have annexed the transfer order at page number 68. My lord, he was directed to join the Jalpaiguri.
Appearing for the state.
But I was informed the learned advocate general is appearing with Miss Shumita Shao.
Where is? Arises out of a transfer.
My lord, the transfer order was initially assailed before the tribunal. The honorable tribunal directed the respondent authorities to consider the prayer of the petitioner and pass a reasoned order. Now, my lord, subsequently, the reasoned order was passed, my lord. In the reasoned order, nothing was stated. It was only directed that you go and join. Now, my lord, he assailed the reasoned order before the honorable tribunal, and the honorable tribunal refused to interfere. Now, that is the primary bone of contention, my lord.
Where is the reasoned order?
My lord. The reasoned order is at, my lord, page number 97, volume 2, internal page number 97, my lord. The entire certified copy is annexed. Page number 97, volume 2. The reasoned order was passed on 14/8/2024 by the Director of Medical Education, West Bengal.
14/8/24.
14/8/24, my lord.
And where is the tribunal's order
My lord.
pursuant to which
My
you have
lord.
filed this?
My lord, it is the certified copy, my lord. It is,
No, the tribunal's order pursuant to which this was filed.
my lord, I'm showing.
2/294.
08294. That order is, my lord. Now, page number 172, my lord. Page number 172, volume 1. Page number 172, volume 1. Now, this is the order dated 18/7/2024.
There is any policy requiring this
My lord, my lord.
representation to be
Lord, may
considered?
I take your lordship's leave, madam?
Yes, yes.
Extremely sorry, my lord.
No, we asked him to proceed. He told us that you are coming.
কতটা বললে?
My lord, জিজ্ঞেস করছেন policy ব্যাপারে। Policy.
So you are seeking enforcement of some guideline or policy.
My lord.
Which is that guideline or policy?
163.
Page number 163. Page number 163. আমাদের পলিসিটা তো
হ্যাঁ।
ওই তো ক্লজ জি হ্যাঁ
Clause C.
my lord, relevant part is in page 166.
Yes.
Page 166 G part, G clause part. I'm reading, my lord. For medical officers of any category with spouse also working as medical officer, the wife of the present petitioner, she is presently under West Bengal General Services, Department of Health and Family Welfare, Purulia. She is working at Purulia. My lord, I'm reading G part, second line. Both officers shall be posted together so far as practicable, but they shall undergo the same category of transfer posting. Next line is very important for us. Medical officers with spouses working in different capacities under the control of the department may also be considered for such benefit of posting. Our humble prayer is, my lord, one order was passed without showing any reason, without having any reason, only they rejected my prayer. Irrelevant, এটা বলো প্রেয়ারটা যে রিজেক্ট
My
হলো।
lord, দেখেছেন, my
ও
lord,
দেখিয়েছো,
হ্যাঁ।
ভেরি গুড।
We have the option.
আর কত পাকাই জানো ওটা? ওটা
এই আমাদের impugned order টা?
ইম্পিউট অর্ডার না, যেটা ওরা প্রথম দিল
97.
97
report for duty.
হ্যাঁ,
ওটা
97
দেখিয়েছেন, report for duty ও দেখেছেন, ট্রাইব্যুনালের ফার্স্ট অর্ডারটা
তুমি দেখিয়েছো,
হ্যাঁ।
ভেরি গুড। না না 97 তো
97. Internal page number 97, volume 2. Internal page number 97, volume 2.
ও এখনো হয়ে গেছে এই যে If your lordship kindly. My lord. Okay. এই বললে ইমপিউন অর্ডারটা কোথায়? ইমপিউন অর্ডারটা বলো কত পাতায়? 4 দিন পরে দেখাবো। Page I pray for an avenue of consolation of my prayer. But first,
308 more inches. 308.
Yes, G we have seen. Anything else?
and my lord, my junior he has already stated, my lord, I do not want to repeat, my lord. Only non-reasoned order has been passed, only stated you go and join. My lord, had it been a case that reason has been given why my prayer was rejected, I could have understood. Nothing has been stated, my lord. Only stated go and join. Subsequently, I preferred applications before the tribunal. There my prayer was rejected.
The tribunal has rejected your OA.
Second volume, page impugned order, my lord, certified copy, page after page 308. এটাই তো, এটাই first order.
4th of April 2025.
Order dated 4th of April 2025.
What is the date of the order?
The order is dated 4th of April 2025 from tribunal. কোন order দেখানোর দরকার আছে? ঠিক আছে তো? Citation ভাবে পড়ার দরকার নেই, বলে দিই যে compilation আমরা দিয়ে দিতে পারি। বাবা রে, জয়েন করার পর লিভ অ্যাপ্লিকেশন দিয়েছিলাম তো। তারপরে এখন আমি যাচ্ছি না, ওরা লিভও দেয়নি, কিছু বলে উনি ওরা।
তারপরে তো আমি চ্যালেঞ্জ করলাম, তারপরে আমাকে ওই অর্ডার হলো, রিজেন্ট অর্ডার ওটা হলো, তারপরে আমি কেটে চ্যালেঞ্জ করলাম, ওটা রিজেক্ট করে দিল, তারপরে আমি বিপত্তি অনারেবল হাই।
Yes.
My lord, this is my prayer, my lord. My lord, your lordship knows everything. There are so many citations I'm not placing, my lord. I have only humble prayer. At least my prayer should be considered.
You are not working since 22.
No, my lord, sorry, my lord. I joined,
It's a
my
very
lord.
disturbing
There
fact.
I have joined.
You joined and after that you submitted leave applications and you
Yes,
are not.
and thereafter I have come before the Honorable CAT and subsequently before the Honorable High Court.
Not CAT, SAT.
Sorry. Oh, sorry, my lord. State Administrative Tribunal.
Yes.
Sorry.
It's a disturbing trend for someone who is in the medical service.
I bow down before your lordships, but my lord kindly appreciates his position. His wife is working somewhere else. I'm not saying that his mother is also sick, but truly his mother is also sick. He has 2 children.
Children somewhere, one somewhere.
Well, somewhere is the children is residing somewhere. I'm residing somewhere. My wife is residing somewhere.
Here for both examinations this year.
Yes. That happens in transfer.
Yes, my lord. But my lord, when there is a policy, my lord, I should try to take the at least advantage of the policy.
Yes, what is the reason? How can you Do you have come out with a policy? You see what your policy says. Huh?
My lord.
Huh. Who is before us?
My lord, here transfer order issued 26th July 2022.
Yes.
My lord, what is his credential, my lord? His credential is assistant professor in, my lord, forensic medicine. 2022, my lord, he was, my lord, asked to join in the Jalpaiguri Medical College. He joined on 29th July, and from 30th July 2022, he was absconded. We tried to give him or serve him at least 3 so-called notices, my lord. He refused to accept. Now, what is his prayer, my lord? Twofold prayer has been made. One, his children are, my lords, they are in a Lilua Don Bosco. So he can be, my lord, posted in Shagor Dotto Medical College, or
We are not
his-
on the merits of the matter. You have come out with a policy.
my lord, can you see
The
the
tribunal passes an order. You don't challenge that order. The mandate is to consider.
yes?
Then how can you not consider? You may not allow, but you are obliged to
Can
consider.
you see the policy, my
You
lord?
please see the order that you have passed pursuant to the tribunal's order. What
My
is
lord,
the reason?
Once
Just show us
see
one
the
reason.
policy, my lord.
Yes. See the policy.
My lord, my lord, transfer policy 18 November 1996, my,
Just read the opening paragraph.
my lord, paragraph number 9.
Please
The
read the
main
opening paragraph. That's your policy.
Yes, my lord, it's my.
Please read what it says.
Please read paragraph number 9. If both the husband and wife,
First paragraph, madam, then para 9.
yes, the undersigned is directed to refer.
The government of West Bengal is committed. 9/11/2011. The memorandum starts with a paragraph.
My lord, this is 18 November 1996.
9/11/2011. At page
Yes, my lord.
163.
The after this also, my lord, this transfer policy also, my lord, reviewed.
When?
My lord, that is, my lord, on 8th March 2022 by the governor.
Where is that?
আমরা তো জানি না রিভিউ করেছে বলছে রিভিউড তো আর কবে করেছে 8 নভেম্বর ততদিনে তো আমাদের মামলা শুরু হয়ে গেছে তাই না রিভিউ করেছে সাবসিকুয়েন্টলি নাকি রিভিউ করেছে ওই এটা অর্ডার
18th, I'm so sorry, my lord, 8th March 2022.
22
That.
No, my lord, we are not aware.
Then
It was reviewed, we do not know even.
go through it.
Yes, my lord.
You go through it. Can you give him a copy? If you have an, or he will get it Xerox. You get it.
Hard copy never.
Is there any such provision in the 22 policy? Same.
But, my lord, kindly read this entire provision, my lord. If both the husband and wife,
Where are you reading?
my lord, this is also paragraph number 9. No, my lord, I'm so sorry. This is paragraph number 9, yes.
Fine.
বলতে যদি
আগের পাতা
ফোনে
থেকে শুরু
ইয়েতে
হচ্ছে।
থাকে তাহলে দেখো শুনে নাও হ্যাঁ অ্যাপিয়ারেন্স দিয়ে দিস এই অ্যাপিয়ারেন্সটা দিস
8/3/22.
Yes, my lord. 8th March 2022. The undersigned is directed to refer to this department number so and so dated 18 November 1996 prescribing guidelines for posting transfer of teachers of the West Bengal Medical Educational Services, my lord. Thereafter, after careful consideration, the governor has been pleased to prescribe in supersession of all previous orders on the subject the following guidelines and general principles to be followed for the purpose of transfer and posting in respect of the teacher belonging to WBMES. Okay. Now, my lord, if you kindly, my lord, come to.
He's in medical education service. You are in medical education.
My lord.
Assistant
Professor.
professor, my lord.
Assistant
Forensic
professor,
medicine, my lord.
Forensic medicine and toxicology.
Here, my lord, paragraph
Paragraph
number
9.
3, 4 is also very important.
Paragraph 9. No, paragraph, paragraph
And
9
paragraph
does not
number
mean
9. Paragraph number 3, 4 also is very important because 4 says, my lord, you have to serve zone 4, 50% of your service tenure.
teachers, তার মানে কি আগে
You have not
cancel?
seen it. How can you argue?
No, my lord, my lord.
Unless you go through
This
it.
was not available in the website, my lord. We did not find it out.
But now it is there. Go
My
through
lord,
it. Otherwise,
my lord, I shall take a copy from her, my lord, and thereafter
it is
I
a
have to
futile
argue.
exercise unless you know what is in this. Why
My
should
lord, my lord.
we are informed by the Leonard State Council that
কবে রাখবে?
considered
Yes,
by the tribunal also.
only that. Another thing I shall see, my lord, whether it has superseded the earlier one or not. Apart from that, I do not want to. I don't want to say anything more.
Let's see.
Grateful,
Just go
my
through
lord,
it.
grateful,
Unless
grateful.
you have seen, how can you
Yes,
address
yes,
this?
My copy fix হলো গো 15 তারিখ 15 grateful, my lord. 15th. Grateful, my lord.
Item number 8.
Last occasion, your lordship, Kalis is the directed to file a supplementary affidavit. We have filed a supplementary affidavit. And one application was also filed for early disposal of. That is, that matter, your lordship, Kalis, this is relating to me, the lord. There. Now, question, Millard, herein, Millard, series of order has been.
Issue has been decided in some case.
What, Millard? It is very much required to be judicial review of the order, my lord, because the policy matter
Of a coordinate bench.
contempt, no, my lord, matter has been issued. The CLI with the stationery can get the local.
What remains, sir? Nothing remains. You have implemented in that case. Where is that order?
Asim Muhammad, I have got the copy, my lord. I have brought that copy.
Then what?
Even my lord, this is
We
very
cannot
much
consider. We cannot
your
consider.
lordship, kindly sees that point was not required.
We cannot.
It was not placed, my learned friend, on my behalf, my lord. I was not there, my lord.
Then you get a review of that order.
My lord, your lordship kindly sees.
You have complied with the order.
No, that is, I am not there, my lord. That is, Asim Muhammad, that is another matter. Here in my lord, I have got a chance to.
So for everyone, the same issue has to be decided afresh.
It is no question, my lord.
Tell us, show us the law.
So your lordship kindly sees the judicial review, my lord.
What judicial review of coordinate bench? That
No,
is what we are asking.
Policy matter which has been held, my lord, that is the after 19 देखिए ये था कॉपी था इग्नोर देखिए ना वो कॉपी था देना
Implementation order. Before that,
अरे जीवन
that is the implementation order. Under that, my lord's order is there.
rules has been there copy गुना दे this point was not raised, my lord. Rule, my lord, that he was held.
Matter pertains to the running allowances of equivalence.
अरे कॉपी देखता दे আমার কোনটা কপি এটা দিয়ে দে সাপ্লিমেন্টারি
Yes.
Only dear Lord, the earlier, kindly consider one thing, my lord. The earlier the rules were not placed before this court, my lord.
Not required. Lord Learned
Because-
Counsel.
Great.
That, but unfortunately, the point in the raise now. That
Actually, it is a case for
Actually,
imposing cost. It is a case for imposing cost. At the cost of public exchequer.
question litigation, my lord, your lordship can see.
Great.
Item number 9.
WPCT.
Rejection.
My lord, I am appearing in person. My lord, in the writ petition, I pray for consideration of my representation for illegal business and operation of unregistered e-rickshaw by the Secretary Department of Transport, my lord. My lord, the said writ petition was dismissed by the learned single bench holding inter alia at page number 86, my lord, of my application.
On the last occasion, 2 points were raised on behalf of the respondents, Locus standi of the
Yes,
petitioner.
yes. Oh,
And-
that's what I'm.
And res judicata also.
No, there is no res judicata. The
But-
locus standi points.
Everything that he says, you will say no. You
My-
know that. But let him say what he is saying.
My-
Then you say no.
my-
Yes.
Learned senior friend is my mentor, one of the mentors. I've learned many things. Yes, my lord.
Where is your writ petition at which page?
My lord, it is at page number. It starts from page number 27 onwards, my lord. 27. My lord, memo of parties is at page number 41.
Your prayer is at 56.
My lord.
And where is the representation of 13.6?
My lord, page number 51.
1.
Oh, my lord, page number, I'm sorry, my lord, page number 81, 81. 81. Sorry. My lord, what is happening? This due to this illegal business and operation, insurance claim will not be there. And if any accident,
Why don't you file PIL? How it can be done by?
my lord, in the earlier round, my lord, we have filed a PI. I am the right holder. I am having the patent. That question was on the previous date asked by your lordships, my lord. My lord, may I take your lordship to kindly page number 77, my lords? My lord, in page number 78, my name has been recorded as an intervener.
You want them to stop the entire business.
My lord, the illegal business, not on legal.
So
my lord, page number 75, 79 is the operative part. In the light of the aforesaid and as a last opportunity, we extend the time for the state government to register all e-rickshaws to be within such time within the state within which the state government authorities would register the unregistered e-rickshaws. However, the plying of unregistered e-rickshaw ought not to be permitted under the guise of the fact that the time provided for registering e-rickshaw has been extended at the behest of the state government. As a consequence, we clarify that while the process of registering the e-rickshaw may go on, period of permitting unregistered e-rickshaw to ply in the state shall stand restricted till 31st August 2019. This means that beyond August 31, 2019,
this is an order passed in PIL.
My lords, in the review petition, PIL has been preferred by someone else. In the state has preferred a review petition. I have intervened to the review petition, and court has finally passed this order. This is the last order, my lord. Thereafter, contempt petitions were brought up. Since I was not the party, I was the intervener. I cannot file the contempt.
You are an intervener. Your name is appearing there.
My lord.
At page 78.
My lord. But I am the intervener. My intervention was only in the review petition, not in the main petition, my lord.
But this order is in the review petition.
My lords.
So you file, this can't be a parallel writ proceeding.
My lord, the court has observed that you don't have the locus standi to file the contempt.
We have seen, no, where it has.
In the review petition, my lord, I have intervened.
Yes.
I have filed the contempt application. The court has said that you are the intervener. You cannot file the contempt.
Where is that order?
My lord, I am pressing that order. My lord.
Whatever it is, how a writ petition such order cannot be passed, whether even if you have the locus standi. It will be a cause for a public interest litigation. It is a matter of policy. It cannot be.
One more thing, my lord, I place before your lordship.
Irrespective of your locus, because locus, they are saying probably we have not gone through it, that you are claiming a propriety over the thing. There is no adjudication till
My
date.
lord, one humble submission, my lord, page
Therefore-
number 61. I have filed a writ petition, not a PIL, before the Tripura High Court for the same self cause. The
We are not
Tripura High Court
concerned.
has ordered this.
Maybe you have to
Tripura High Court-
satisfy us because Tripura High Court has ordered, we will not order.
No, so just for the persuasive value, my lord,
Yes.
just for understanding this.
But we are asking you a
This
specific
court,
query.
our court is independent court and it will take its own view.
Yes.
My lord, may I take your lordship to page number 61? This is the writ petition I have preferred before the Honorable Tripura High Court on the self same cause for unregistered illegal business and operation of e-rickshaw, wherein at page number 66, my lord, page number 67, the court has ordered, having observed thus and directed accordingly, this writ petition are allowed to the extent as indicative above. However, this decision will have nothing to do with the writ petition filed by the petitioner in respect of their patent right. Before the it is made clear that if any violation notice even by the petitioner, they can file a complaint to the Joint Transport Commissioner directly, who in turn will take appropriate action on the said complaint. There shall be no reluctance to take punitive action against the person who violate the law. My lord, section 39 specific Motor Vehicle Act specifically mandates.
Therefore, we are saying it's a cause for PIL.
My
You
lord, I
can't
have
pass
the
such
right,
an order.
I have the right, my lord. If I file the PIL,
You go and file.
my lord,
Nobody is
if I
stopping.
file the PIL, what will happen? I am the right
I don't
holder.
know what will happen.
My lord, I am the right holder. I
Then
am the
they
right
will
holder.
say you have an interest.
I have an interest, my lord.
Yes. So
I
therefore,
admit this.
so therefore, what
My
can be
lord,
done?
if
It cannot
I-
be. You cannot resort to a writ proceeding for this.
My lord, I have the right.
It
That's
cannot
why
be
it can
done.
come up before the writ, my lord. I cannot go to PIL, my lord. My humble submission is this.
Sorry.
Because if I go to PIL,
We
my
don't
lord,
know.
I will try to.
We
fetch
don't know
something
whether
that-
you have a right.
My lord,
There is no declaration of.
May I take your lordship?
There
to
is
the-
no declaration of patent in your favor till
My
now.
lord, may I take your lordship to the my supplementary affidavits, my lord?
We don't find any infirmity with your.
My lord, in the supplementary affidavit, may I take your lordship to my supplementary affidavit, which I have
No,
filed?
you have to overcome the maintainability and your locus. These two things.
My lord,
Then you
for that only your lordship has passed an order to file a supplementary affidavit.
maybe.
My lord, may I take your lordship to my supplementary affidavits,
This
my
is,
lord?
no, there is no scope for passing any order by us.
My lord,
Since your propriety which you claim is not yet decided, there are two aspects. One is you cannot claim to be having a copy, whatever you call it.
my lord, state was a party in the title suit before the Alipur court.
Maybe
That order,
doesn't matter.
My
That
lord,
doesn't make it any better for you.
my lord, may I take your lordship to the state's order, the director of transport order?
We are not concerned. You get it implemented. Why do you need us to say anything?
My lord,
Either you file a PIL or we cannot. The Honorable Single Judge has rightly rejected. This is a matter of policy. You want them to implement a policy. How it can be done by a writ petition? Cannot be done. And you have no locus. That also is correct.
I have not prayed something which cannot be granted. I prayed for
According to
considerable
us, it
authorities
is.
only.
According to us, it
Authority
is.
can reject it. If I, being a citizen, if I cannot say that something is going illegal.
You pursue your representation. Why do you need a court's direction?
My
for
lord, they
this
have
one?
not considered my representation after passing of so many times. They can reject it. The authority, at least, my lord, being a taxpayer, I can file a representation to our government, and our government should have means reply to that.
Representation disposal order we don't pass.
Because, my lord, being a citizen, if I don't have the right to say something illegal is
That
happening.
does not mean that you can file a representation before any authority for anything that comes to your mind.
No, my lord.
Authorities have to carry on the business of the state.
My lord, I am
not just sitting there to pass orders on representation.
Most humbly, my lord, I am only on the part of illegality. State cannot, being a state, my lord, Article 12 says, state, and as per the other tenets of the Constitution, state cannot facilitate illegal business and operation. State cannot set its eyes on illegal business and operation. And being a right holder, I am the patent holder. I have to go to the court with clean hands. If I go to PIL court, my lord, I only seek for a consideration, my lord, most humbly, because in consideration, the secretary can reject my representation. They have the authority. I am not seeking anything which is against the law. Section 39 of the Motor Vehicle Act says every vehicle has to be registered. Being a citizen, being a taxpayer, I can say to the state that this is happening wrong. Because if I take those e-rickshaws for my convenience, for going to any place, if any accident happens, my lord, I won't get the insurance.
Correct. Well, we are saying it's a cause for PIL. That's precisely what we are saying. it can't be such a narrow issue. It's a much larger issue. Non-registration is not such a simple thing that you stop it because it is not possible, and the court should refrain from passing orders which it cannot implement. So there is a whole exercise which is required to be done.
Then
How to regulate it, how to check it, how to deal with those which are found on the road unregistered. How this can be done?
My lord,
Only in a PIL, not
I'm
otherwise.
I'm absolutely agreeable
Cannot be
with you,
done.
whatever fallen from your lordship, but I have only one reservation, my lord, that I am the patent holder, my lord.
You claim to be, we don't know.
I claim to be that.
claim to
That
be.
is what my submission.
But you have
I
not
claim
shown to
be.
the, you have not shown to
Till
the
now,
single judge.
Decree has not been passed.
You have not shown to the single judge that you are a patent holder. You have not shown the single judge that you are a patent holder.
Then, my lord, whatever
Today you are not a patent holder.
my lord, I have
In
not
your
shown.
mind, you are a patent holder, but
My
there
lord,
is no declaration.
I
of your
agree to
being.
this proposition. Then, my lord, I will withdraw this and file a fresh writ petition before the single judge with this patent. I am the right holder because I have not shown it to the learned single judge.
The
Learned
learned counsel for the petition.
My lord, he already moved before the honorable division.
We are not saying
So what
anything.
The division bench said. Lordship kindly.
Why should we see that? We are considering the honorable single judge order unnecessary submission you are making.
Raise judicata point because same point.
We don't
was
know.
taken
Let
and
him
the
file.
division bench said on his submission
Learned counsel
that he
for the
is
petitioner
covered by the
submits.
Ten.
My lordship, my lordship, I'm appearing for the petitioner side, my lordship. My senior Bikash Ranjan Bhattacharya is engaged into some other matters, and advocate on record Shantidas Bhomik is facing an eye illness, so that's why my lordship, not today. Kindly take this matter on Thursday, my lordship.
Not today, take it up on Thursday.
Thursday, my lordship.
Not today does not make it Thursday. Not today makes it Monday.
My lordship, so kindly take this matter on Thursday, my lordship.
As prayed, 1 week.
Item number 11.
My lord, on behalf of Mr. Subroto Satra, my lord, may I pray for not today, my lord.
My lord,
He has
this-
not come to court.
My lord, this is that matter, my lord, where the age bar is the question. This
See, in
But-
one case, I think we should consider the apex court judgment, which they are harping on in every case.
my lord, that does not follow the guidelines of RB 99 of 2010, my lord.
What am I saying? We should consider it in some case.
Yes.
Has it been considered? You say not regarding RB 99. We have seen it is not regarding RB
Yes, ma'am.
99. We have seen relying on that they have come out with a combined policy.
Yes.
So what has to be done? Is there any decision on that aspect?
My lord, they are showing something. My lord.
Is there any decision on that aspect by this High Court? We are not asking you what they are saying, what you are saying.
No,
They are saying wrong, you are saying right. We are saying, has this issue been considered and decided in any judgment of the High Court?
Yes, my lord. My lord,
Judgment.
that is WPCT 88 of.
No, in that case, the Supreme Court judgment has not been considered.
Kindly allows me, my lord.
Please don't argue on merits.
No, my lord,
Where,
I am
where
not
that
arguing.
judgment
No, my
has
lord,
been
I am not
considered.
arguing on merits, my lord.
Yes.
My lord, after the passing of WPCT 88 of 2023, a review was filed. That review was dismissed with cost.
And after that, they approached the Supreme Court on the self-same cause of action. That was dismissed. And
So therefore, we should not consider the Supreme Court judgment. We are asking you whether that Supreme Court judgment has, you are arguing on merits.
No, my lord, I'm not arguing.
You are arguing on the merits that what they are saying has no force. We are not asking you whether what they are saying has any force. We are asking you whether this aspect has been considered and held that this issue is meaningless now.
No, my lord, that
Any declaration or that yes, it has to be considered.
my lord, the judgment that they are relying upon is
Yes, the
something
judgment
new, my
of
lord.
his lordship. It's not new. It's quite an old judgment.
My lord, that has not been relied in those previous cases.
So they are stopped.
My lord,
They are stopped from relying on that.
they are not stopped, my lord.
Then
But
therefore, has it been considered a simple question? Either you say I don't know, or you know that it has not been considered, or you know that some judgment has been considered.
my lord, the judgment that they are relying
They are
upon.
relying upon, has it been considered by any coordinate bench?
No, my lord.
Not considered. Consider it. And you say that the judgment 88 has attained finality up to Supreme.
Yes.
Say that this is already governing the present RP. We should give it a finality. That is what we are anxious about. In every case, they will come and say this judgment not considered, judgment not considered. So let us consider it. You say that the RB 99, which falls for consideration,
does not.
In this state, that has attained the judgment 88 has attained finality to the apex court.
Yes.
They say
Well,
that
the
no.
self-same project, self-same people.
Obviously,
Yes.
obviously, they are relying on something which is of an earlier policy.
Yes.
That was
they
where it was said that they will have some kind of preferential claim in a recruitment process.
No, the claim, their point of view is that the age relaxation that has been given is plus 15.
What are we saying, sir?
My lord.
You are eager to argue your case.
No, my
We
lord.
are trying.
It is
we
their
are
point,
trying.
my lord.
No, it is not there. In that case, the Supreme Court has held that they are only entitled to a preference in the recruitment process. In that case, because the policy there was different. In your case, it's not a preference in recruitment process. It is consideration for giving an appointment.
Yes, ma'am.
Yes, my lord. That is what we are saying. Both has to be reconciled. Either we say that yes, that has to be considered and applied henceforward, or we say that no, that is in a totally different set of circumstances.
My lord, my lord.
Let the issue be settled in every case. They are coming forward with this. So we are asking you. In this case, we can do it. Obviously,
My
they
lord.
will raise that issue.
My lord, this can be done.
Let us consider it. Where is that judgment, Supreme Court?
My lord, they have filed
my
a.
lord, not today, my lord. Kindly, I am not appearing.
They have
in
filed a
this matter, my lord.
compilation
Of that, they have annexed the judgment.
The
So
judgment.
let us. We'll hear you on that aspect. You come with those judgments. WPCT 88 review.
Those are already on record, my lord.
We'll take it into consideration as prayed by learned counsel for the respondent.
Only the Supreme Court, the apex court judgment that on reliance on reference to 88 that I haven't annexed. I will bring that on record also.
Whatever you want, you can bring it on.
Rest are all on record, man.
So unless we decide this case, we'll not take up any of those matters now. What is the case? Your case number?
My lord, my case number is.
If any other counsel wants to join in addressing on that day, more than welcome.
130 WPCT 130.
This is 130.
130.
So now all these matters, land loser, it will come after 130.
23. Southeastern Railway. Grateful.
Item number 12.
Your Lordship. Adjournment.
Yes.
Your Lordship, I was humbly praying if it could be taken on Tuesday.
Why? What is the matter? All matters you are seeking adjournment?
Item 12.
Come on Monday, not today.
Much of
Grateful, Your Lordship.
13.
Also, my lord. Let it come on 28th. You also appear in that matter.
Also, my lord.
Let us finish this aspect. Every case, it is unnecessarily.
Your Lordship, all points are finished by your Lordship.
That
In my
judgment,
case,
only that judgment
my-
remains.
he could not know, my Lord, he could not know. There is the order of your Lordships regarding the age bar. But I
No, no,
produced,
the judgment we will
I
consider.
produced before your Lordship,
We
they have
will
already.
consider the Supreme Court judgment.
That Supreme Court judgment, I have said, my Lord, 15 years, that is not the.
So 28th we will consider. You come on 28th, both the matters will tag together. You also address. List this along with 130.
There are several issues. One relates to age bar, one relates to P.
We are not on that aspect. Only whether the Supreme Court judgment they are harping on, that will apply in your case or not. That is all.
Apply no.
Rest everything is decided by us in many cases.
That is separate issue. That is separate.
That's a separate issue.
এটা হচ্ছে অন্য সার্কুলার অনুযায়ী
Just along with WPCT 130. Hold that judgment does not start following. Or if we hold that. 14. Go upstairs. None appears for either parties. Three weeks ago. Right. Last day also.
$15.
I appear on behalf of the applicant responding to your lordship. Supplementary affidavit has been served upon us only yesterday. Lordship, will you kindly give us some opportunity to take instructions and come
It
back?
has been filed.
Yes, no, my lord, it has not been filed. It is with me, my lord.
So can we record you are filing it?
Yes, yes, yes.
Supplementary affidavit is.
Important.
Same, next 15 to 18.
18.
Yes, 15, 16, 17, 18, my lord.
In all the
Filing.
matters, in your
But-
filing supplementary
Yes,
in all.
yes, yes, ma'am.
Same order in 15 to 18. Just tag the supplementary affidavits.
The 16.